Hi again, everybody. Mr. Drummond here, coming to you on March 30th. Just wanted to go over a few of the assignments that we've been working through over these first 3 weeks of shutdown. Again, we're just all doing the best that we can here. Okay. I appreciate the efforts that you guys are putting in. I hope that you all know that you can always reach out to me, email, Remind, Google Classroom. I'm going to be hosting a Zoom. I'm going to post about it, but I'm going to be hosting a Zoom meeting later this week, probably on Tuesday, and then again later in the week for people that want help going through some of the assignments. We can do it live. You can show me what you're working on. I can help you through it. In the meantime, though, I thought I would just give you a little guidance on the assignments regarding Ohio's state constitution, okay? So if you go back to last week, my last video, okay, and again, hope everybody's staying safe, healthy, doing all those things that we have to do to stop the spread of this virus, okay? I know it's boring, but hopefully everyone's just doing the things that they need to do, taking care of themselves, and by taking care of yourself, you're taking care of your family. So hopefully everybody's doing those things. What I wanted to do was go over the assignments regarding the Ohio Constitution. So the page that is right after the notes on the Ohio Constitution, it's an iCivics reading, okay? I thought maybe what we could do is I could just go through that and read that, okay, aloud, if that would help anybody while you're going through it. So if you want to have out the page that looks like that, it says History of Ohio's Constitution, okay? And it's 2 quick pages of reading, and then we can go through the answers together, okay? If you've not done this yet, go through it with me for the first time right now. If you've already done it, just kind of listen, and then we're going to go over the answers so you can check yourself here, okay? So, History of Ohio's Constitution. Remember, we're talking about 3 big problems. Remember, 2 attempts at a constitution in Ohio, right? 1802, the original Constitution. Then in 1851, we realized some problems with that first one. We made a bunch of revisions and started kind of almost from scratch, made a lot of changes. Excuse me. So, first things first, History of Ohio's Constitution. So I'm going to start reading, okay? And if this is helpful to you, by all means listen. If not, you can fast forward through this part. Use this however you want. You can rewind, you can listen again to things. I want this to be helpful to you guys. So, History of Ohio's Constitution, Ohio 1.0. Before it was a state, Ohio was part of the Northwest Territory and was governed under the Northwest Ordinance, created in 1787. The ordinance prohibited slavery, protected freedom of worship, the right to a jury, and a number of other basic rights. Over the next 20 years, the population in the Ohio area grew. And in 1802, President Thomas Jefferson signed a bill allowing for the establishment of a new state. Before it could be added to the Union, this new state needed a new constitution. So a convention was formed and got to work. The 1802 Constitution created a state government with most of the power in the hands of the legislature, called the General Assembly. So legislative branch, right? Representatives of the people that make laws. The governor and executive branch had very little power, as did the judicial branch. So governor and judicial branch, almost no power under the first Constitution in 1802, okay? With a constitution, the U.S. Congress recognized Ohio as a state, and Jefferson signed it into law. The first meeting of the General Assembly was held in Chillicothe, Ohio. That's Ohio's first capital, on March 1st, 1803. This date is celebrated as Ohio's birth date. Time for a change. It didn't take long for Ohioans to find some flaws in the initial structure of the state government. A national economic crisis hit in 1837, right? The economy started to decline throughout the whole nation, and it was actually worse in Ohio for a couple of reasons. Leaving many to blame their state government and a lack of economic policy. So Ohio's government isn't established, isn't ready to deal with this crisis. So they start to question whether it's a good system. Early banks did not have any rules or many rules to follow. So many were weak and collapsed, taking the people's money with them. Remember, if you got your money in a bank and the bank collapses because it's been irresponsible, in these days, your money is gone. All right. Now, that's not the case anymore. You know, we have federal deposit insurance and stuff like that. But in these days, people trusted the bank. The bank folds because it's not making good decisions because the state isn't regulating it. And then they're out all the money that they had deposited in the bank. The economic panic and the lessons learned from governing the new state led many to support constitutional reform. Another constitutional convention was held, and the state was presented with a new constitution in 1851. The new constitution aimed to address the lack of balance between the branches of government, as well as issues relating to state funding. Ohio 2.0, the executive branch. The 1802 Constitution only created the offices of the governor and the Secretary of State. And the Secretary of State was selected by the General Assembly. The powers of the governor were limited to issuing pardons, filling official vacancies when the General Assembly wasn't in session, acting as commander-in-chief of the state militia, and calling the General Assembly into session in extraordinary circumstances or situations. So not much real power. In 1851, or the 1851 Constitution did not give much more power to the governor, but it did expand the executive branch. Okay, remember, the governor is the head of the executive branch, but the governor is not the only person in the executive branch. Before the 1851 Constitution, there was only one other job title, Secretary of State, and they weren't even elected by the people. They were appointed by the legislature. Okay, so the governor's going to get some company here. Okay, they're going to create lieutenant governor, which is like a vice president, right? We got a president and a vice president in the federal system. We got a governor and a lieutenant governor. Okay, it's going to create the office of auditor, treasurer, and attorney general, providing additional executive oversight and guidance. These offices were no longer appointed by the General Assembly, but elected by the people. Okay, so, excuse me. The legislature, remember, had too much power, right? That was one of the problems we talked about last week, okay? How are we going to limit its power? We're going to take powers away from it, okay? We're going to give them to the people. So we're going to expand the executive branch, right? And we're going to let the people pick who's in it, not the legislature. Okay, we don't want people in the executive branch thinking they owe their job to the legislature. We want them to be able to, remember, check, right? Keep within the lines, right? The executive branch needs to be able to stop the legislative branch from doing things that are not good. The legislative branch has to be able to check the executive. Judicial has to be able to stop the president or the governor in this case, okay? We need to bring this back into balance rather than having this big, huge, powerful legislature and teeny tiny judicial and executive branches, okay? So picking back up at the top of the next page where it says History of Ohio's Constitution, Ohio 2.0, the legislative branch. The General Assembly, which that's what we call the legislative branch in Ohio, was created to act as the main governmental branch and held the majority of power in the state government. All major officials except the governor were appointed by this branch rather than elected by the people of the state. Laws were passed that favored some citizens and companies over others. Their legislative actions were unchecked by the other branches, and the General Assembly soon gained the reputation of being corrupt. In an effort to rebalance these branches, the 1851 Constitution stripped the General Assembly of many of their powers. They were no longer given the power to appoint key executive officers, and judges. The legislature was no longer able to pass laws retroactively, nor were they allowed to pass laws that did not apply to everyone equally. The General Assembly maintained its most powerful branch status, but its authority had been lessened in favor of the executive and judicial branches. So we want the legislature still in Ohio to be the most powerful, because remember, Americans in general, even to this day, okay, are distrustful of too much power with one person, right? We don't want a super powerful president, although the president has become more powerful in the last few decades, but that's a different topic. We don't want a governor with a ton of power because that's only one person. We don't want judges with a ton of power because they're only one person. We want legislatures who are the closest to the people, right? Live in their communities, get elected, most often. We want them to have the power because if they start to abuse it, the people can check them. Okay, so we still want that, but we don't want it to be a hugely powerful legislature and teeny tiny executive and judicial. We want the legislature to be really powerful, but also an executive branch and judicial branch, while maybe they aren't quite as powerful as the legislature, they're still big enough to stop them from abusing their power. Okay? Get my phone back here. All right. The judicial branch, Ohio 2.0, the judicial branch. The original Constitution created a rather simple and streamlined judicial system, a Supreme Court for the whole state and courts of common pleas within each county. The Supreme Court was required to meet at least once a year in each of the 9 counties that were established in 1802. In the nearly 50 years that followed, the number of counties jumped to 88. That's a lot of travel. So when the first Constitution was written, 9 counties. Not that hard to get to 9 counties, right? You could do 1 a month and still have 3 months left over. As the state grows, right, we don't want these huge giant counties, so we start splitting it up. No, we've got 88 counties, okay? So you could do 1 a week if you were the Supreme Court and still fall short. You'd only get about 2/3 of them done. So we start to see that the Supreme Court can't get its job done, right? And remember, they're not taking cars. They're not flying private jets. They're taking horse-drawn carriages around the whole state, 88 counties. It's almost impossible to do that in a year, okay? And actually stay in each county and hear the cases you need to hear as well, okay? So big problem, right? People in the courts of common plea they have the right to an appeal. The only place to go to that is the Supreme Court, and they got to wait for the Supreme Court to come around to their county. So there's a big backup or backlog of cases. Big problem. Okay? People might start taking things into their own hands. If they can't access the courts, right, they might start to do things that maybe it's violent, maybe it's unlawful in some way. So we don't want that. How did we address it? To address the population growth and the growing demands on the court, the 1851 Constitution created an additional level of district courts to bridge the gap between the lower state courts and the Supreme Court. Judges were no longer appointed by the General Assembly. They were elected by the people. And the travel requirement was also removed, allowing the Supreme Court to stay put. So we're going to insert a level. Here's the Supreme Court. Here are the courts of common pleas. This is where all the trials happen, right? Everybody starts here. We're going to insert the district court level so that they're kind of like a filter. They filter out stuff before it has to get to the Supreme Court. And we're going to split the state up into districts, and each one's going to have its own district court, okay, for appeals. So you don't have, if you're in Youngstown, right, and you got a problem, you don't have to wait for somebody in Columbus to do it. There's a district that includes, Northeast Ohio, and you can go there. All right. So another important change. Okay. Finally, economic policy. In the early years of the state, the government racked up a lot of debt. Some debt is okay, but the General Assembly had used the public's money irresponsibly. One law passed by the General Assembly required the state to provide financial aid to railroad, canal, and other companies, benefiting individual businessmen connected to the officials. Right? So my buddy owns a railroad. I'm going to make a law that anytime he asks for money to help him with a project, the state has to help. That's a pretty good deal for the businessman, not a great deal for Ohio's taxpayers. Okay. So the state government was investing in private businesses, and if those businesses failed, the state lost that investment. These kind of laws, risky investments, and corruption helped spur calls for change. The 1851 Constitution addressed the corruption and financial concerns in a number of ways. It set a $750,000 limit on state debt. It also required that money be used for exactly what it was borrowed for. In other words, if you borrow state money to build a bridge, you had to build a bridge, not a new house for a corrupt legislator, which was happening, right? People were saying, yeah, we're going to make we're going to withdraw funds from the state's bank account and we're going to use it for, this vague purpose. And then all of a sudden, legislature's buddy has a new business, or legislator's, friend that has a railroad company has a bunch of new rail lines that they didn't have to pay for. So the state is saying, if you say, you can't just say we're taking this money to do stuff. You got to say we're going to build a bridge here at this location, and then we're going to be able to check up because the other branches are strong enough now to oversee the legislature and see, did you really use that money for what you said you were going to? Same for taxes. If you raise tax money to create a school, you can't use it for a road. Poll taxes were outlawed, and all property had to be taxed in a uniform way. Excuse me. I swear I don't have corona. Just my regular problems I've been dealing with here. Okay. So if you scroll down, or I'm scrolling, you're flipping to, it says primary source activity. Okay. And it says the history of Ohio's Constitution, and it's got questions about all those examples that we see. Okay. So the page before it looks like this, right? These are there's little boxes. There's a 1, 2, 3, 4, 5, 6, 7. Okay. You see 1, 2, 3, 4, 5, 6, 7, right? All of these are little quotes from the Constitution. On the left side is the 1803 Constitution, or the 1802 Constitution. Ohio became a state in 1803. The Constitution that was written in 1802 is here. That's the old one. The Constitution that was written in 1851 is here. It's the new one. So follow along with me, all right, and we'll answer these questions. So the first question, example 1, what 2 elements have been added to this rule about the General Assembly spending state money? Why did the 1851 Constitution add these 2 details? Well, example 1, the 1802 Constitution says, no money shall be drawn from the Treasury, but in consequence of appropriation made by law. Okay, so they're just saying the General Assembly has to say they want it. In 1851, they're going to say, no money shall be drawn from the Treasury except in pursuance of a specific appropriation made by law, and no appropriation shall be made for a longer period than 2 years. So here's the 2 things that you're going to answer for the first example. The legislative branch has to specifically say what they're going to spend the money on, and they can only spend money 2 years at a time. Okay, so we can't just say we're going to give money to this project forever. Every 2 years, the General Assembly has to stop. They've got to look at the entire budget, and they've got to say, well, this is working, let's keep that. This is not working, let's stop giving money to that. Okay, so that we can keep our debt down. All right. Excuse me. All right. Examples 2 and and why did they do that? Again, we're trying to keep the debt down, right? We can't just spend money like it's going out of style. We've got to be able to justify why were you spending this money and say exactly what we're spending the money on. Examples 2 and 3. What 2 restrictions are being placed on the General Assembly in these excerpts? If you go back up to the previous page, the 1802 Constitution has no mention of whatever these issues are. There's nothing, it says no mention of this. What does example 2 say? All laws of a general nature shall have a uniform operation throughout the state. Uniform means the same. Operation means how they work. So the laws, so here's your answer. For examples 2 and 3, the first thing they're going to do is they're going to say all laws have to apply equally to all people. Okay. And the second thing that they're saying, right, if you go down to example 3, the General Assembly shall have no power to pass retroactive laws. So the second part of that answer is no retroactive laws. What does that mean? All right, if you're going to outlaw, has always been against the law, but just to give you an easy example, all right? If there's a law against murder, okay? If there was no law against murder and you murdered somebody, they can't the next week make a law against murder and punish you for murdering someone before it was against the law. Right? That's not a great example because murder has always been illegal, but I'm trying to come up with an easy example to think of, what a retroactive law was. So say I didn't like a particular student, okay? And I know that student wears they wear a orange hoodie every day, okay? And then one day, I say, from today forward, no orange hoodies in my classroom, okay? And the next day, the student doesn't wear an orange hoodie. I can't punish them for wearing an orange hoodie before it was against the rules to wear orange hoodies, right? I can't target that one specific student by doing that, okay? I hope that makes sense, and if you have more questions about that, you can feel free to ask me, but it was a way for the legislature to get people, right? To say, you do this particular thing, we're going to make that thing illegal, and then we're going to punish you for doing it before it was illegal, right? How can I can't read your mind. I didn't know it was illegal, all right? Or it wasn't illegal. Now you said it was illegal. I stopped doing it. You can't punish me for doing it before I knew it was illegal, all right? Hopefully that makes sense. So examples 2 and 3, laws have to apply equally to everybody, and you can't make retroactive laws, right? Laws that look backwards. Retro means, if something has a retro style, that means it looks like it was from, the olden days, right? Retro means back, okay? They can't look at behavior before an activity was illegal, okay? So, all right, example 4, okay? How did the executive change in 1851? Consider the who and the how. Okay, well, the governor is still the governor. They're still elected, so that's the same, okay? But we're going to add, if you look at example 4, the executive department shall consist of a governor. We've always had a governor. We're going to add a lieutenant governor. That's a new position. We've always had the Secretary of State, but now the Secretary of State is going to be elected. So that's a difference. We're going to add an auditor. We're going to add a treasurer. And we're going to add an attorney general. So we're beefing up the executive branch, right? Used to be puny, just 2 people. One of them was elected by the legislature. Now we're going to beef it up some. We're going to add people to it, and we're going to make it more influential because the people choose it. Example 5, which courts were added to the judicial system in 1851? We don't even have to go back to look at this. We talked about it, right? We're going to add the district court level. Here's the Court of Common Pleas where everybody starts. Here is the district court, and up here is the Supreme Court, right? We're adding the district court level to filter out some cases before they go to the Supreme Court to filter out most cases, okay? We're also going to add something called a probate court, which a probate court deals with distributing property after someone passes away, like say they don't have a will, or maybe determining the authenticity of a will. In Ohio, they also do things like marriage licenses. Sometimes like adoption and custody stuff is done through the probate court. But for our purposes, what we want to focus on is Supreme Court, District Court of Appeals, Common Pleas Court. You start here, you go here, the District Court, and then if you don't get satisfaction at the District Court level, now you can try the Supreme Court, rather than just having Supreme Court, Court of Common Pleas. Pardon me. Sorry, I need a drink of water here. All right. How was the selection of judges and justices changed between 1802 and 1851? Remember, who picked judges, made them extremely powerful, was the legislative branch. They decided who was going to be a judge. We're trying to make the legislative branch less powerful. So now who's going to pick judges? The people, right? So that's why if you go around town in October, November, most years you'll see retain judge so-and-so, or elect judge so-and-so, right? Or elect so-and-so for judge. We pick now, okay? There's pluses and minuses to that. And if we were together, that's a really good conversation to have about criminal justice, especially, if I'm a judge coming up for re-election, right? And I want to look like I'm tough on crime, maybe do I start to sentence people to more severe punishments just so I look good to the people, whether or not it's the right thing to do or not? Do we want judges, trying to do what the people want versus what the law says? That's a controversy. Other people say to have true justice, the people have to be able to make a determination about the quality of the people carrying out justice. So I wish we were together. That's a really good debate to have. Maybe we'll be together one day and we can have that. But in Ohio, the people elect judges. Okay. In the state of Ohio, the people elect judges. Okay. We've taken that power from the legislative branch and given it to the people of Ohio. In the federal system, and we'll talk about this in another video, in the federal system, the president appoints federal judges. Okay. We don't do that in Ohio. The people elect judges. Okay. So there's your answer there. Okay. We went from having the legislature appoint them to having citizens elect them. All right, last one. All right, and then we're gonna we'll knock off for the day. Okay, and then I'll come back with you later on, and I'll post another video. Okay, and you can just use these however you want. Okay, but this is good enough for one stretch right here. Example 7. How did the 1851 Constitution change the travel requirement of the state Supreme Court? Excuse me. So remember, we've got the Supreme Court, they're in central Ohio, right? Capital. Before this Constitution, they had to travel to every single county, all 88 of them, every year. Now we don't have to do that, right? Because what have we inserted? We have Court of Common Pleas and a Supreme Court, but now we've created a District Court of Appeals. So now the state is split up into districts. We've got appeals court in every district. Okay. We've got a Supreme Court still, but they're going to stay put. And people can come to them if they have a problem that can't get dealt with at the lower two levels. Okay. So no more traveling. All right. Supreme Court stays put. People travel to the Supreme Court now if they can't get their issue solved by the Court of Common Pleas and the District Court. All right, that is the first part of that activity. All right, I'll log back on later on. And like I said, don't forget to be on the lookout for a live Zoom meeting that I'm going to have. We'll call it like office hours, right? In college, your professor will be available in their office hours for a couple hours a week. So I will create a Zoom meeting, and I'll share it on Classroom, and I'll try to get it on Remind as well. And if anybody has any questions at all, or if you just miss seeing me, which I doubt, but I would like to see you guys. I'm sure you're all missing me terribly, but I do miss you guys. It would be nice to see you, check in, make sure everyone's doing okay. We'll have a Zoom meeting, and it's a free app. Don't have to pay for it. You just put it on your phone. You don't even actually have to download the app. If you just click, I'll send everybody a link. If you click on the link, it'll take you right to Zoom. You put in your name, and then you're in. All right, so I'll share a link later today, probably on the 30th, and maybe tomorrow, Tuesday, we'll shoot for that, and we can have more if people come. But I'd like to see you. I'd like to answer any questions you have. So for now, that's the first part of the Ohio Constitution assignment. Okay, we'll come back later on in the week, finish up the Ohio Constitution, and then we'll start talking about how the government affects the economy, which we have seen right now is a great example of what the government can do to try to help the economy. So we'll get into that later on this week. Hoping to catch up with you guys soon. Hope everyone's well. Thanks for your attention, and I'll talk to you later. Bye.